So this conversation is going to be about unforced PTAB errors, pitfalls patent owners should avoid, and this is a panel that was really inspired by the writing that Steve has done for us recently. So let me introduce the panel, and then we'll begin the conversations. First, we'll begin from audience's left, and we'll go to right, is Peter Sullivan. And Peter is a registered patent attorney and co-chair of Foley Hoag's Patent Trial and Appeal Board Practice Group. Thanks for being here, Peter. Next to Peter is Steve Schreiner, and Steve is a partner in Carmichael IP, and he focuses on all aspects of IP litigation, patent litigation, and primarily representing patent owners, right?
Correct.
And thanks for writing the materials. Sure. And then next to Steve, we have Dan Drolet, and Dan is a founder and managing director of Liquidex Capital LLC, which is a leading PE-backed IP asset management valuation and advisory investment firm. Dan, thanks for being here.
Thank you.
And last but not least is Richard Kim, and Richard is VP of IP strategy for Netlist, rather. And last week he was a defense attorney doing defense litigation and defense of PTAB work. So we have a wide variety of opinion here. And what I'd like to do is walk through, like we have been with all the other panels, and start to get preliminary thoughts. What I will do is I'll rather than just go down in the order I introduced them, since Steve, this panel was you and I put together based on your articles. I'll give you the first word here today on a big picture level. What is it that you'd like to have the audience focus in on?
Virtually all of my practice is now IPRs, and primarily for patent owners, like Gene said. And I think the first big picture item for me is, when you're filing papers before the PTAB, know your audience. This harkens back to some comments on the prior panel. This is not district court. It's not the same rules, and you don't have the same decision makers. So you really need to know your audience. The strategies and tactics that work in district court normally don't work before the PTAB. And I really do believe you need to have PTAB specialists handling those matters. So just as an example, colorful stories about the invention or about how the invention came to be, or colorful stories about the inventor, that plays great in district court before a jury and often before a judge. The PTAB does not care about that. And so you start fluffing up your filings with material like that. Number one, they don't care about it. Number two, you lose credibility because you don't look like you're a PTAB specialist. So that's my main first message, is know your audience.
Great. Thanks a lot, Steve. Pete, your preliminary thoughts.
Sure. I think I agree with you, Steve, about all those points. About knowing your audience, and I come at it from a different perspective, since my litigation experience isn't just IP. I do other work in the general area. So in terms of audience, I have to counsel my clients to understand that this is even unique for what they may have experienced. If they're used to being in different kinds of lawsuits, this is going to look different from even your IP lawsuits. I think it looks a lot more like a re-examination panel, in terms of how people dig into the technology. I think that the fact that we have experts is an additional wild card that we'll probably talk about a little bit more. But I feel like in terms of like unforced errors and having my client understand things, I want to give them some rocks to stand on in terms of what this process is going to look like. And I usually talk about re-examinations and examinations as more of it than litigation.
Okay, great. Thanks a lot, Pete. Dan, your initial thoughts here on this topic.
Well, we're further up the upstream. We're not attorneys, we're investors, and we're looking at it at an early stage. And the biggest issue we've seen is twofold. One, on our operations and how we do things, and then how we identify clients, pull them in, either identify partnerships or investments. Probably the biggest issue we see is overly broad claims. And that's our biggest issue of not investing. due to the fact that now, instead of just taking on a client to license or those types of services, we have to assume that it's going to go to the PTAB.
Okay.
So we have to identify the funders, we have to identify the service providers, we have to identify the entire team before we agree to make an investment.
And Richard, your thoughts?
Sure. I can think of a couple of mistakes that I think patent owners should avoid. And one of the mistakes is not battle testing your patents and addressing any issues that you see before you make an assertion of those patents. For example, if there are invalidity concerns, you can file a reissue application to address those invalidity concerns. On the infringement side, if there's claim construction concerns, you can file broadening and reissue if you're within the 2-year period. Things like that, I think, could help improve the, or decrease the uncertainty of your enforcement campaign. And a second mistake that I've seen patent owners make is to believe that IPR practice before the PTAB is the same or similar to the patent prosecution practice. We've heard that PTAB or IPR practice is very different from litigation practice, but I would submit that there's a lot more similarities between IPR practice and district court litigation practice than there are between IPR and patent prosecution practice. And oftentimes I see briefing and oral arguments being made with sort of like a prosecution mindset. And it's a shotgun approach where they're getting into the weeds of the technical arguments. That's just not an effective way to proceed in an IPR. I think more of a litigation mindset and approach. And granted, there are differences, but you have to persuade. It's a highly adversarial procedure, right? And you have to persuade the judge that your position is more correct than the other side's position. So all the skill sets of litigation where you have to persuade someone come to bear.
Okay.
Yeah.
Great. So let me ask this. I know it's on the list of things. I think it was in one of your articles, Steve. It's certainly in some of the emails we swapped back and forth that has already come up in a big way already, is the POPR. What do you do in the POP? And everybody seems to have thoughts, and I want all of you to comment on this. But what is one mistake, at least, that you see most often in a POPR, in your opinion? Realizing that some of you may disagree, you may think that mistake that one person thinks is actually the right strategy, and hopefully we'll dive into that. But Steve, go ahead first.
Yeah, I would say the one mistake that I see in POPRs is patent owners, counsel submitting basically, omnibus arguments, just, all the different merits arguments they can think of. And, that's really problematic, because, when you're there at the institution stage, you've got this low threshold, right? Reasonable likelihood that just one claim might be invalid. And so if you put forth all those arguments, and the board decides under that low threshold that what the petitioner says is good enough, you've tainted all of those arguments, and then that becomes problematic because when if there's institution, now you've basically got to get the same panel to come out a different way on the factual findings in connection with those arguments. And you've got the whole issue of confirmation bias with that. You're asking the panel to come out a different way. So my feeling is, you don't want to put in all your merits arguments. You might put in, if you think you've got a silver bullet or two in terms of merits arguments, maybe you go ahead and put those in there in your POPR to give yourself a shot in non-institution. But I generally try to focus on other things, procedural issues, whether it's FinTIV or serial petitions or the status of non-patent literature as not being a permissible printed publication. But that's the biggest mistake I see in POPRs.
Okay, Peter, I want to ask you to comment on that as well, but before, you do primarily life sciences, I think you said, right?
Yeah, I do more
Yeah.
life sciences these days.
So if at any point in time, there's a difference between what you might say is relates, generally
Sure.
speaking, to versus life sciences, please bring that up, if you
Right.
will.
Well, the one thing about life sciences, I'll say, is they've been a passenger on this AIA train, and I don't think they realized that they were going to the same destination as Techland. So
Right.
that's been a bit of an issue. On the PBO, the preliminary owner's, patent owner's response, there are two things that I'd like to get out of it. First, I want to get out. And the other thing I want to do is I do want to stress test some of the arguments I think are strongest. Because sometimes you get from the institute, you may have an institution decision, but you'll get in the institution decision, the panel saying, this may have some merit, but I want to go have a hearing on it. And sometimes that gives you a little bit of intelligence about where you need to be thinking about your arguments. I agree, confirmation bias is a thing we have to worry about. And sometimes the panel will give you some indication that they're not so persuaded by some aspect of the petition. And if I can tease that out, I want to try to. I'm not really keep your powder dry as far as going for it. I want to see if I have some home run arguments that I think are legitimate. I want to take a shot at them because I may learn that I'm almost halfway there. And if I'm almost halfway there, I may be able to supplement my record, supplement my declarations, and make the gap filled, because nobody gets to talk to the judges, right? We learn through like 2 decision points, and sometimes you realize when you get a final written decision, if you didn't do anything before that maybe you could have made a better argument earlier. So I try to use that as intelligence.
Okay, great. And Dan, I'll come to you last because you're the business guy on this. But Richard, your thoughts, because it seems like we have 2 different perspectives here, and I understand the facts and cases and make a difference. But generally speaking, what do you think?
Yeah, I mean, I think it's a very strategic decision that's, in my mind, completely dependent on the merits of your arguments of why the petition is insufficient, right? So I think if you have a slam dunk argument that has a really good chance of avoiding institution, you need to make that. But if that argument is sort of good, but reasonable minds can differ on that position, you have to really think about, well, do I want to telegraph or show my cards at this point and have them prepare to address these issues, give them more time to prepare? So I think it's a strategic decision, but if you have any chance to avoid institution in the first place, to me, that outweighs a lot of other considerations. So typically, if you have a good argument, we would make that in the POPR.
Okay, and does that include substantive arguments, or are you, like Steve, mostly looking at procedural, offensive related?
I mean, if we have a really good, what is slam dunk is an ambiguous term, but if we feel that we have a really good slam dunk argument as to all the claims, all the independent claims, then we would most likely make that and avoid institution.
Okay, before I go to Dan to get the business guy to set us straight here, what do the money people want? Let me go through the lawyers here again. What in your mind is a slam dunk, and how often is there a slam dunk, and how often might you think it's a slam dunk and you wind up not being correct? And I think all of those things kind of play into which path you choose, right? Like if you look at this and say, okay, well, this is a slam dunk and you're 99 times out of 100 correct, well, then that gives you a lot of confidence, right? But if you think this is a slam dunk and you're no more than 50-50, then that should probably influence what you do as well. So I'm just trying to figure out where we're at. And I'll start in reverse order. Richard.
Yeah, I mean, it's rare that you'll have a slam dunk argument. And sometimes you'll have a good argument, and in those situations, you sort of have to weigh all the pros and cons, right? And I would, and my boss Chuck has very strong opinions about this as well. As he mentioned, he wants to avoid institution altogether. And statistically, you can avoid, if you can avoid institution 33% of the time, as opposed to having some claim survive only 15% of the time after institution, that would counsel towards avoiding, putting an emphasis on avoiding institution, right? So that's a weighting factor that I would say if you have a reasonable chance at avoiding institution, not necessarily a slam dunk, then you take that.
Okay.
Yeah.
Peter, what say you?
I don't know if I've ever seen a slam dunk. I just think that there are, sometimes you feel strongly about arguments, and I also, again, going back to this, I'm in the minority on this, but I think it's important to learn early what you're up against with your panel. And even if you've lost an argument, you know not to focus on it, because you're going to spend the next few months arguing dependent claims, arguing other ways around it. You're going to take different approaches. So,
Do you think that is influenced by the fact that you do a lot of life sciences work, or is you just think that that's generally?
I don't know. I think that's just my style.
Okay.
I don't. Like I said, I may be completely wrong about this, but my feeling is like we had a case where, you get an institution decision and you make a decision: do I amend claims? Do I fight the dependent claims? And as a result, you sometimes get mixed rulings out because you've learned about what not to spend time on. And my feeling is it's important to know
where you stand.
Yeah, and I also, like, in terms of worrying about exposing my expert to cross, well, then shame on me. Like, my job is to get an expert and to battle test him before he files a declaration, so that I know what he's going to say. Not wait for the other side to come up with good arguments. If that's happened, then I didn't do my job very well.
Yeah. Steve, your thoughts here?
Yeah, I think a slam dunk argument is normally only going to be where you believe there's a missing limitation. Slam dunk argument is not, there's a lack of motivation to combine, or reasonable expectation of success, something like that. And actually, I do believe in normally putting forward at least one or two merits arguments, that cut across all the claims. I really, for reasons Peter just alluded to, number one, it gives you a chance, and Richard, it gives you a chance at non-institution, right? And sometimes it works. The board sees that this limitation was not established by the petitioner and the petitioner's expert. And then the second thing is that you do get feedback from the board. The board will sometimes, it depends on the panel, but they will sometimes, give you a signal. They might institute, but they'll say, there is some question about whether limitation 1.2 is met based on these references. And that's a signal to you that, you're on the right track, and it's also something you can reference back to in your patent owner response and say, the board recognized that this limitation is missing. So there was an old kind of mindset or theory that you don't present any merits arguments in your preliminary response, and basically to me that's just sort of like accepting institution as fait accompli, and I don't think that's a good approach at all.
Yeah. Okay, so Dan, you're sort of, as I understand it, correct me if I'm wrong, operate at the intersection of the lawyers, the client, and maybe even litigation funders,
Investing partners,
yeah. Right? So what do you want to see? I mean, I would think that you would probably put a high premium on not getting this instituted at all, but I don't know, because I talked to some in litigation funding people, and they're not afraid of getting instituted. Actually, some of them want to get instituted,
Right.
so that because they've done their due diligence, they like the patent, not afraid of the prior art, and what they want to do is hurry up, get through to the point where some claims remain, so that they can get busy about suing and collecting. What say you?
Well, we normally leave that up to the legal teams to make that determination, but the biggest challenge that we used to see, and now we kind of coach our patent owners, is essentially properly preserve your evidence, and make sure that your legal team has that to do the best job possible, similar to what Peter was talking about. Preserve your arguments, because if you don't, from the early start, you have a good chance of losing.
Okay. So I think during the pre-call, you mentioned something about one of the concerns that you see a lot is you work with some people, and it's just so typically the innovator, the person who is maybe a novice to this whole
Right,
area,
right.
thinks that if only I could talk to the petitioner, they'll understand my point of view. And you've worked with some people who have
I've
made
ne-
that mistake, right?
Yeah, I've
Can you
never
tell us-
met an inventor that wanted to talk about their invention.
Yeah.
Yeah.
So tell
joking.
tell us about this problem and how it's reared its head.
Well, I mean, it really doesn't matter who the inventor is, how intelligent they are. If it's an innovation, they want to talk about it, and they need to talk about it. But it's one of those things that you do not want to put them in front of the court, or unless they have to be in terms of the PTAB. Because they'll go on and on and on, talk about how, in flowery language, how great their IP is and why it's different. And of course, they didn't do the broadest prior art searches. So, and they don't have the evidence. So there's an issue there where we bring the team on early to coach that inventor, extract all the information, and make sure that the team is ready.
But I think maybe I misheard you during the call, but I thought you had said you even have worked with some folks that take it upon themselves that before they even contact an attorney in the first instance,
Oh, yeah.
that they reach out and start trying to explain.
Cease and desist letters and all kinds of different things that come to us. We've already done this. They're infringing. Well, how do you know they're infringing? Well, they're doing the same thing. And of course, you've got to go through the claims and every word. And of course, the claim is this long,
Right.
Instead of all the different claims. But that's probably the biggest challenge that we see is companies coming to us with 10, 12 patents, assuming they have the industry locked up, sending out cease and desist, or kind of these, let's work together, you owe us licensing revenue. And what we found is, tech companies, large tech companies, even medium-sized and small tech companies, it depends on their revenue size, they get requests every day. Here's a patent that we want you to license. And, we call that soft licensing. And I think I was talking to Scott about that last night, where that's, there's no threat of litigation on soft licensing. And the issue is, unless it's extremely strategic, companies just aren't doing it anymore. So the only way they're paying attention to that IP is if there's claim charts and there's assumptions that these people have a team together and they're about to get sued. So from our perspective, if there's not legislative change, the patent office is probably going to go away in 10 years because everybody's moving to trade secrets.
Yeah, that is a problem that I see, and it came up a little bit on some of the previous panel about, your inventions are valuable, but your data may be the most valuable piece here, and because your data is not touchable by the PTAB, you can't get PTAB'd for secrets, I guess, right?
Also, in life sciences, there's data exclusivity.
Yep.
So, but the patents still matter. I mean, the difference between an investable drug and a non-investable drug is going to matter about whether there's going to be, term on the back end of the data. If there's less certainty that patents will survive, the VCs out there and the people who are looking, frankly, the pharma companies who are licensing in these innovations from the smaller companies, they're just going to make a calculation and say, well, we're not going to invest in this because unless we know we have term at the back end, we don't think we're going to make enough money during the data exclusivity period.
Yeah.
Yeah, there's no strict liability for trade secrets though, right? So I don't see patents ever going away. I think they're certainly weakened, and we need to do something about that. But I don't see a system where the patents or the patent office is going to close. There is so much uncertainty there, and one of my initial comments was we can do a lot to decrease that uncertainty and you can't do this, it's cost prohibitive to do this for every application, right? But if you have a group of patents and you've identified a few that you think are very valuable and you're planning on asserting them, you could do a whole lot before you actually start the licensing campaign, litigation campaign, and get this train running that you're not going to be able to stop once you start it, right? So you can do a whole lot of due diligence with your, when I was in private practice, I would always enjoy representing defendants and petitioners because I knew we were going to do a scorched earth search for prior art, and almost always we would find prior art that the examiner didn't find or just didn't consider during prosecution. And I think at that point you spend hundreds of hours, right, looking at all that, as opposed to in the examination phase. I think examiners will spend 5 to 10 hours, maybe more, just on average. That disparity, is the reason why we have so many institutions. I think it's the resources that go into preparing a petition, doing the prior art search. Its magnitude's greater, and so it's not that the examiners are making mistakes. They're doing the best they can in the time that they have, and they're doing a great job. But it just doesn't compare to what happens subsequently, right? So to try to balance that out, you need to, before you assert a patent, try to do that same due diligence beforehand.
Yeah, no, and I agree. I think that the answer ultimately needs to be do less on examination. And because it seems to me to be just, we live in this world where, well, certainly at the PTAB, there's no presumption of validity. There's just not. And that's fine if we want to pick that lane, but then, and I realize the examiners do, as Drew pointed out when he was examining, you have 21 hours, and that's fairly, 20 to 23, 4 hours is probably pretty standard for most. Some get more, some get a lot less, depending on the complexity. And it's not enough to get to the certainty that we say we want, but it's so much that it takes, there's this backlog, and it's a growing backlog, and it takes years to get the rights and all that sort of thing. And I just think it's foolish for us to not realize that 98% of these things aren't going to get litigated. They're not going to matter to anybody. They might be tag-along assets if you're licensing 30, 40,000 patent portfolio.
Right.
But if we're going to have a PTAB that's really going to roll up their sleeves and look for a couple of 100 hours, the attorneys and for prior art, then maybe what we should do is do, a rational effort at the front end, and realize that the real analysis is going to come at the back end. And a lot of people don't like that choice either.
It's hard to invest in that.
Yeah.
That becomes a trademark
really
registration.
risky
It's
to
kind of a
invest in.
registration system.
Yeah.
Right. But no, I agree, and everybody hates that, right? But how do you solve for the delta, right? Because the thing is, Richard makes a compelling case there that and a lot of folks have mentioned this already, is look, if you're paying 20, 30, 40, 50,000, whatever you're paying, 50,000 would be a lot to get a patent for most patents. And then somebody's going to pay at least 10x that to challenge it. Well, it doesn't take a rocket scientist to figure out what's going to happen in a lot of cases, right? And so I don't know what the solution is. What's more rational? The other rational thing that would make a lot of sense, but it's tough, as the previous panel just brought up, is get less patents and focus on the energy on the ones that matter the most. But under our
you don't
current
know
system,
which ones matter the most
that's
until
the
you can
problem.
start-
That's the problem.
Yeah, but that's
Good idea on that.
Go ahead, Steve.
Yeah, kind of building off what Richard said. I think obviously you can't put in a huge effort into conducting searches for every application you file, but we do have this thing called the continuation practice, right? And notwithstanding the cases on
Right.
limits and latches, you could file continuations, and if the rule should be you always have a live con in your family. And so later on, when you start to realize that, okay, these are the golden patents, these are the ones that have value in the marketplace, you can file those cons, and then you can make the investment in doing the extra searches and so forth to reduce the certainty. So the uncertainty. So that's the one thing I would say. The other thing is the premise of what you're saying. that maybe we need to focus more on this uncertainty on the back end. That's kind of accepting that the PTAB's validation rate, which hovers around 70%, killing all claims in final written decisions, that's right, or that's fair or proper. And I'm not sure I'm there with that.
Well, no, I don't think it's fair either, and I also am troubled. I'm troubled by a lot of these things because it just seems like if like we all locked ourselves in a room and we don't come out until we have reached at least an 80% consensus, we would come up with a system that is very different than what we have. And I just look, these are the patents that are worth fighting over. We're spending $500,000 to $1 million to challenge or defend at the PTAB. What are the plastic Adirondack chairs or the hookah pipe with integrated radio? I mean, if these patents have problems, what kind of problems does the other 98% of patents that never get looked at more than the 14 to 24 hours that examiners normally get? Pete, you look like you want to say something.
I wish I had a good answer for you. I think I was thinking about this issue about just being more robust in a search at the outset. But the trouble, there are headwinds for that. Like we counsel our clients, don't do a bunch of searches because then then you're tagged for recklessness or willfulness, and then so we don't do that. Or if we do it, then if we do a search, we have to give all the things we found, even though we think we did this massive robust search. We know there are five references we really like, but we got to send Drew the whole box because we have to keep our our duty of candor in place, and we have to avoid inequitable conduct down the road. So we put more work on the examiners. So I don't know how to get that solved either. Maybe there's a two-track thing where we do most cases don't get examined, but what they do, they get examined more harshly with more fees, and maybe that's a way to do it. It seems like whatever we come up with will require some legislation to deal with it.
Yeah. Go ahead. Well, I would just say before that, I'm not sure that that's entirely true. I do think, like as Director Kapos was saying here yesterday, I do think, when he came in, he very publicly said that the patents that aren't issued are as damaging, if not more damaging, than the incorrect patents that do issue. Because if a patent that should have issued doesn't get issued, then it has negative implications for funding and investment and all kinds of stuff, right? And then the other thing too is that if that's the case, if that's the choice, then I just think the PTAB instituting less and maybe them focusing more resources on the ones that are the worst ones, the worst patents, or maybe even the ones, it doesn't have to be the worst patent, but the patent that's the most valuable. Maybe we should be taking more looks at those, right? But not just, I think the institution is too high. I see problems like if we're going to do it this way, then we can't do that. If we're going to do that, then we can't do this. And legislation would be great, but as Judge Michel seems to think that we're probably 2 to 3 years away. Steve,
can I address Peter's last comment?
Yeah, sure.
Yeah,
and then Steve, go.
To me, the calculus is pretty simple. I mean, you're either going to spend $500,000 minimum to $1 million plus in an IPR, as opposed to spending maybe $100,000 on a really, that's a really, really good prior art search and analysis, right? And obviously, this assumes you're going to have really good counsel, really good analysis on that front end, right? So you spend $100,000 max on a good prior art search. If necessary, you're going to file a reissue application, right? Another 20, 30, all right, let's say 50,000, all right? And hopefully that reissue application will address some prior art and really greatly enhance or increase your chances of avoiding institution, weaken whatever arguments they might have. So if you can do that, and you want to have all this prior art before the examiner during the reissue. You want to so that will make it more difficult for the petitioner to say, oh, this prior art wasn't considered. So I just see only pluses and benefits for doing that. And it's also going to decrease the institution rate, decrease the invalidation rate. And I just think patent owners should be doing more of that.
Okay. Steve, and then Dan.
Yeah, I think that makes a lot of sense. You know, if we're talking about how to reduce uncertainty for patent owners before they assert their patents, to not just do due diligence, but to do a full search. And if those claims need to be tweaked, if they need to be tightened up, go ahead and file a reissue application or file a request for ex parte reexamination and get that patent into tip-top shape before you take it into the deep waters of litigation and district court and the PTAB.
Mm-hmm. Dan?
So I want to go back to my
Sure.
last comment real quick. It may have been a little bit of hyperbole about the elimination of the patent office, but it's not hyperbole to talk about the killing of innovation and people investing in that innovation. So that's the point I want to go back to. In terms of the strongest patents and going after those, the reason people go after those is because the amount of money they're going to lose if they don't go after it. Mm-hmm. So the challenge that we have is representing patent owners and portfolios of patents and patents we own and patents we invest in. We spend lots of money on that. Is that if companies can continue to take it, net list, 15 years, and how many people keep going? Eventually, one of these companies is going to take, if they're coming at it from different angles, it's going to happen. So something has to change from that perspective as well, because it's at what point do you invest in those patents if somebody's going to be able to take them away, and then you've got to spend all that money. So the amount of millions of dollars going into operations is ridiculous.
Yeah.
It should go into innovation.
No, I agree, and it was maybe a little hyperbole to say the patent office isn't going to be there, but I do ask, and I've been asking more people lately now, is like, why are you even trying to get a patent? I mean, I think if I was a chief IP counsel or a general counsel, I would probably be filing applications, but then I would be putting off prosecution as long and as far into the future as I can on any level, because maybe we will get Prevail, maybe we will get Para,
Right.
maybe we will get Restore, and I do not want to rush to get to the end game any quicker than I absolutely have to. And in fact, I would also think that filing, PCT or maybe filing a unitary patent or getting a unitary patent might make a lot more sense. Certainly getting a German patent makes sense. And I do think if we don't fix the patent office from the innovator's perspective, that pretty soon people are going to start asking that question more and more. Why am I doing this? It just feels like it's the very definition of insanity. It's, you do the same thing over and over again expecting a different result.
Right, but like you said, life is long and the pendulum swings. So the one thing about that is conditions change. I mean, we can go back to the 90s, and we can remember there were automatic injunctions absent exceptional circumstances upon infringement. You had the teaching suggestion motivation test that required you to find the suggestion in the reference itself. All this before KSR. We had, I think willfulness was proven in like 80-90% of the cases. Judge Moore had done a study of that back in the late 90s. You had a pro-patent bent that started, frankly, with the beginning of the Federal Circuit. The Federal Circuit was built with the idea that we need to protect patent rights. And then things changed. eBay shows up, KSR shows up. To go down a real rabbit hole, the Texas PI bar is thwarted because Texas passes product liability reform, tort reform, and a whole bunch of out-of-work Texas lawyers became busy in patent courts in Marshall. The asymmetric discovery obligations of a big company against a small company. All of these things happened to bring the pendulum swinging way up, and now all those resources swing right back. But that's not to say that you can't swing again. The end is very modest, but she's worked on actually Nobel Prize winning science, and she started working on it in the 90s, and we're still litigating cases in Europe today. That we could never have predicted what the SPC law was going to be when we were doing that work. But we take the law as it shows up. So my advice to anybody is to keep plugging, because you don't know what the
No,
system is
and
gonna be.
I get that. And to some extent, when I say that, I'm playing devil's advocate and asking, But I also know, and I've always told people, the only thing I can tell you with any confidence at all anymore in the patent space is if you don't apply for a patent, you're not going to get one.
Right, right. And I don't want to sound like we're negative from an investment standpoint. We're concerned because we're investing in patents left and right in terms of AI, industries that are in transition, raising and pulling in millions and millions of dollars that many people are excited about in terms of innovation and moving that direction. It's just concerning what can happen, and you have to go through this entire effort and discussion and education and all of that when people say, wait a minute, the patent office is going to give me all these patents, but they're going to take them away? Yeah, that's what's going to happen possibly. So you have to make sure that whatever you do on the front end has to be extremely planned and extremely quality.
So let me ask you guys this. I mean, because look, I read a lot of patents, probably more than anybody in this room, because several times a year, what I will just do is I will just go through every patent that was issued that week, and click through them and read the claims and look at them and that sort of thing. So I don't dissect them the way that you guys do, but I see an awful lot of stupidity. I see an awful lot of, oh my God, why would anybody have filed on that? For a variety of reasons. From it being the hookah pipe with integrated radio to, like, let's say that's the world's greatest idea.
I think that's a good idea.
Yeah, it's a good idea, right? But it can't. I'm sorry. And I know I wrote an article years ago that if you want a patent, just take something that has nothing to do with the radio and integrated radio, and you too can get a patent. But that can't be what KSR stands for, right? So it ranges from that to like, who in their right mind thought they were going to make any money on that, And I realized I would have advised against the pet rock, and that made enough money to be worth it. But I just wonder, do you think patent owners are just filing too many patents, diluting their capital, not focusing on the stuff that has the highest percentage chance? And again, I'll give you another example. I know a guy, all those Snuggie probably, you've seen the Snuggie on TV, right? I know somebody an invention company who does a lot of work, help inventors on a whole variety of things, passed on the Snuggie. So there will be mistakes. Right. I'm not saying it, but you look at some of this stuff and it's like, my God, couldn't we have had like a 95% confidence level that we should have spent the dollar somewhere else? Dan, you first, since you're the business guy.
Well, what we find is we receive a lot of potential clients that want us to work with them where they have one patent, two patents, and you look at the patent, and it's something for a very small issue, small application, and we start having a discussion with them to understand it more, and it wasn't about business why they got the patent. What we learn is this is about emotion that somebody carries around to change their life, expecting that when they get this patent issued, their life's going to change.
Right.
And they
Dump
don't
truck full of
understand
money is
that
going to back up on their doorstep.
Right. So it's like we use this term. It's like a baby. They love this baby. They've been carrying this baby. It's been growing with them. They've got to do something with it. And it's goes back to kind of the American way of changing your life and pulling yourself up from the bootstraps and go make something. And they don't think about, is this something that's going to really have a large market opportunity? And so that comes a lot of times secondary. Mm-hmm. And those are the small inventors that have one or two patents. Those aren't the shareholder groups. Those aren't the small operating companies that know what they're doing. It's usually the independent inventor that just wants to go do this and think they can make it happen, which is great. You don't want to change that.
Right. So we've probably got about 13 minutes here. Scott, I'm going to ask you for your take on all of this or any of this here in a minute, and we're going to go back to, hopefully in rapid fire at the end, talk about a few other things. But it seems like what we're focusing on right here now, Scott, is that a lot of the quote-unquote pitfalls or mistakes that people can make, patent owners at the PTAB, start way before you ever anywhere near the PTAB. And you and I have talked about that a lot, about what goes into applications and choices, and then people being shocked that they don't have what they really thought they had or what they wanted. What say you about any or all of this?
Yeah, I think that's the point. At these conferences, we focus so much on the back end, and to your point, you ask companies, well, why are you getting patents today? I think the question is, why are you getting patents today using the same strategies you used 20 years ago
Right.
with the same commodity budgets, and then you're surprised when you don't have these magic assets 10 years later? You have to put different inputs into the control system to get something out because the PTAB hasn't changed. So you need to prosecute differently. You know, the old way of, well, just get me a broad claim that reads on the entire industry, that's not working, right? It's developing the portfolio. It's, you know, getting more claims, structuring them differently, varying the language, the scope, all of those things that you kind of did in prosecution, you know, 15, 20 years ago, but not really, right? You took the apparatus claims, you ripped out the structure, you called them method claims. If I can kill the apparatus claims, the method claims get you 0. Same thing with dependent claims that just have throwaway features. This is what you're paying for. You know, this is what you're paying for when you set these low prosecution budgets. You don't get prosecutors that are learning your business and know where the tight corners are. You're just getting general work product, and it's not doing well on the back end. So we spend so much time talking about correction, but nobody wants to do anything different on the front end, and that's what it comes down to. It's examination quality, which on the one hand, we can't control what goes on in the patent office, but we all know if you file a Track 1 application, it's basically a registration system. That's flying right through. I can't tell you how many prosecution histories I've reviewed, and the Track 1 filings get almost no examination. And then I'll say that at a forum like this, and the prosecutors will come up after and say, stop telling our secrets, right?
Right.
So we know that there's games being played on the front end, but nobody wants to talk about that. We just want to say, throw out the system and let's go back to what we were all comfortable with. So there's like a little bit of this like pervasive stubbornness in the system that we just pretend isn't there.
That's being kind, a little bit. There's, you know, there's a lot of stubbornness here, and the big issue, as big as any of them, is people wanting to pay for in 2025 or in last year 2024 whatever you were paying in 1980. You know, all we know, I can predict, and I tell people this all the time. I can predict what the next case dealing with, for example, like 112 at the Federal Circuit is going to say, and it's going to say you didn't disclose enough. Okay, and the case after it, you know what it's going to say? Well, you still didn't disclose enough.
Yeah.
You know, and you still didn't disclose enough. And some of that is shocking because the Federal Circuit doesn't ever seem to want to tell us what we really need to do, which annoys me. But it's not shocking all at the same time. If you're only going to be paying what you paid 40 years ago for a patent, and today, you should not be shocked.
Yeah, there's a throttle, a cash, throttle you have to deal with startups because they have to pay the engineers to do the thing. And when you look at the list of, and they have to have founding documents, and we look at all the things that they have to spend money, legal spend, I think the patents, at least at the outset, are pretty low on the priority list. And sometimes,
Very low.
And sometimes they're not even ripe yet. Like, you see plenty of half-baked patents that didn't need to get filed because 2 years later, that development team of yours actually built something that's saleable and that could be better covered under, and then maybe it becomes a continuation of part or something.
And I think that's, why David Kapelos yesterday was talking about this Track 3, which is you get deferred examination. I think that would be a great idea. It's for 30 months. The statute allows for it. The PTO has never really moved in that direction.
We have provisionals already, We could probably expand
Well,
it.
but you could do it yourself with PCT, but the filing fees at the front end are so much higher.
Yeah.
Steve?
Yeah, I think the commodification of patent prosecution over the last 20, 25 years, that's a huge problem. I remember when I started my career and I did patent prosecution, we had reasonable budgets, and often, I'd give a budget for each office action, that sort of thing, that was tailored to, what I was dealing with, and it got transformed. It's a completely commodified system. It's an assembly line system. You have people that are just, cranking out, office action responses, and there's a little menu. It's like a McDonald's menu. Everything's fixed fee. No matter what the complexity is, and you get what you pay for. You end up getting patents that are not very good, with claims that are too broad, claims that sometimes are, not very coherent.
Yeah.
And then that's got to play into a PTAB, right? It doesn't work well.
Right. Okay. Does anybody have any questions? Okay. One of the things, and this maybe will take us to the end, we'll see how far it gets us, that I think you all mentioned during the pre-call, and it comes up whenever we talk about appeals or making arguments to tribunals, is bringing up too much is a real mistake. You know, it's one thing for whoever's reviewing to think that, well, maybe there were 1, 2, maybe 3 mistakes if the case were big enough, but, you know, somebody was telling me they saw, and this may have been a Federal Circuit filing, but 27 errors raised.
Wow.
You know, well, even if you're doing 20, I mean, you only get but so many pages, right? So some of those errors you're mentioning in less than a paragraph. I mean, it just seems like, and I don't know, is it bad lawyering? Is it bad management of clients? Is it clients that just won't listen? Or is it a little bit of all the above? And I mean, so what say you guys about that particular issue? Peter, we'll start with you first.
Sure. Well, I think that's just a subset of what all litigators have to do for all courts. The fact is that there's only so much attention. The word attention comes up a lot this week. Attention span with judges, and if you're not giving your best arguments first, you know, they'll say, "All right, what else you got?" But you know, they're losing patience with you. The idea that you're going to throw everything at the wall and see what sticks, more often than not, isn't, you know, a successful long-term strategy.
Steve?
Yeah, I think you have to really make a conscious effort not to put forward too many arguments, and specifically not to put forward too many secondary arguments that are kind of tenuous. You know, when you get done with your brief, you know, your patent owner response, for example, you know, you should go through it and make a conscious effort to evaluate each argument. You know, do I really need this one in here? Is this one really going to help? Does this one really have a chance? Because all those secondary arguments, you know, they clog up and distract from your main arguments that really, you know, that really are potent, and they can also undercut your, you know, credibility before the board. You know, if you're making some, you know, weak argument that the references are not analogous to the patent and they shouldn't be used in the combination, you know, you're not going to win on that argument and you're going to lose credibility. So I think you need to make a conscious, deliberate effort to go through your brief and remove those secondary arguments.
Dan?
Yeah, I think from a district court, starting at district court and then the PTAB, you know, with a district court and a jury, you know, you've got lots of arguments and the jury likes to hear those things, but when you get a PTAB, the judges are pretty technical. They understand what you're talking about, and you should only put forth your strongest arguments and your strongest expert witness.
Richard?
Yeah, this goes back to my second mistake that I mentioned at the beginning of the discussion, which is you can't pursue PTAB, IPR practice before the PTAB as you would as a patent prosecutor, where you're taking this shotgun approach and putting forth all these technical arguments that some may be strong, some may be weak, and seeing what the examiner or the judges like. You know, I think, you know, you have to be a lot more surgical, selective. You don't want to make weak arguments that dilute your strong arguments. And it's the same considerations that you would be arguing in front of a jury, right? You can't, and I'm not saying the APJs are like juries. They're obviously much more experienced, probably much more intelligent. But you have to keep in mind some of the APJs might not have the technical background that's on point to your, and we've seen that. Some APJ don't have the technical background that matches what the patent is talking about. And some APJs are a lot more junior and a lot less experienced on your panel than the others. So you got to know your audience, and your goal has to be, I have to persuade this panel of 3 people that my position is better than my other side's position. And if you have a very strong, persuasive advocate on the other side, obviously that becomes much more difficult. And if you're trying to get into the weeds and arguing technical discussions where the experts, or where it becomes a battle of the experts, you're not going to win that. So, yeah, the more simple and concise you can make your arguments, I think that's the best chances of winning before the panel.
Okay. And Steve, I want to bring this up just because we have a whole bunch of things, and we're going to work on an article on this panel because there's a lot of good advice here. But two of the bullet points you sent me in an email is avoid teaching away arguments. They almost never work. And then the next bullet point I thought was just funny. It was avoid analogous arts arguments. They're worse than the lottery. So quickly, can you tell us, give us your thoughts on obviousness, which is such a big part of these cases?
Yeah, I mean, I think there's certain arguments that just don't play well to the PTAB judges. One is arguing, non-analogous art. Another is arguing, hindsight reconstruction. Putting those types of arguments forward as, self-standing arguments in favor of non-obviousness, they're almost never going to win your case. Really, you need to address the issue head on, which is motivation to combine, and you need to show why a PTAB would not make the combination of references that's been proposed, and the reasoning for that, and the evidence for that, and those are the types of things you need to do to prevail. I do hate kind of the lottery metaphor when it comes to patents, but I have to admit that when I'm talking to a patent owner considering a campaign, it is in a sense a lottery. You need multiple patents so that you have multiple opportunities before the PTAB so that you can get at least some of those asserted claims through and keep your litigation alive.
Great. And I'll give each of you a very rapid fire opportunity to wrap up. We'll go down the row. Peter, your final thoughts.
Yeah, I agree with Steve. Some things that would play better in juries don't play well. Motivation to combine, I think it's a hugely important issue that I think is underanalyzed at the board and even at the federal circuit. And I think it's, but it's also, that's what it is. So I try to counsel my clients understand that.
Good, great, thanks. Dan, your final thought.
Well, I think I want to end on a positive note. I think, there's a lot of good with the PTAB and what it does. But I think we've all, over the years, identified what's not good and what needs to change. And as Judge Michel said yesterday, if we all work together in our different areas and try and push on that change, we'll see that. If we don't, we just have our heads down and we just keep focusing on the things that we're focusing on, nothing's really going to change because these legislators don't understand this problem. They're not seeing it every day, they're not involved with it. And innovators don't have the lobbyists that big company. I mean, we have ACG and companies like that, but Google's got teams that are sitting here, UNDC and all the other big companies. So, but it's something that can be fixed.
Great, thanks a lot, Dan. Richard, your final thought.
So I think I'm going to end on a negative note, and I just want to, I guess, echo what Judge Michel said yesterday, and that is I think our patent system is somewhat broken. It's skewed against patent owners and inventors, it's cliche, but it's so true. It's hurting innovation, hurting companies, tech companies, science companies here in the U.S., and whatever we can do to champion this cause, to fix the system, I think we all need to put our heads together and try to figure a way to do that. So, yeah, that's what I'll end on.
Great, thanks a lot, Richard. And Steve, final word goes to you.
Yeah, sure. I think most people in this room and even people who are on the petitioner side would agree that the patent system's out of balance. If you're a petitioner, you might couch it in terms of, well, the pendulum, swings this way, and now it's kind of swung the other way a little bit. But the patent system, there's no doubt it's out of balance. And the question is, how do we motivate our legislators to actually get interested in this? I don't know if the policy debate stimulates them. I think in terms of, what about the competitiveness of the U.S. patent system? The U.S. patent system's always been a point of pride for us, right? It's kind of the best in the world. It's part of American exceptionalism. And is there a way to frame this debate, when you've got the ascendance, in my view, of the European patent system with the unitary patent court, uniform patent court, and the unitary patent? Is the U.S. patent system going to be less competitive with the European patent system, less competitive with China? Maybe that's a way to motivate our legislators to really dig into this.
Great. Awesome. Well, thank you very much for a wonderful conversation. We solved all the problems.
We've identified all of them.
Yeah, we've identified them. Yeah, the solution is greatly exaggerated. But all right. So you all, thank you very much. And we're going to take a break now.